All right, Mr. Hawley, we're ready when you are.
May it please the court. Good morning. My name is Eric Hawley. I represent the plaintiff appellant Trey Agbonzee in this premises liability slip and fall case in which the district court granted summary judgment in favor of Wal-Mart because it said that the plaintiff lacked sufficient evidence as to the knowledge element of the premises claim. And Mrs. Agbonzee is asking the court to reverse and remand because there is sufficient evidence as to both the actual notice element and a constructive notice.
At what point in the video is there any evidence that anyone across the 12-minute span noticed or perceived the spill?
Yes, Your Honor. There is evidence in the video, first of all, when the two employees, I believe this is about 3 minutes after the spill occurred, two employees walk over and stand directly over the spill for about 2 minutes.
After? You said, yeah, they're standing there talking, but they're not standing over the, there's nothing in their demeanor, they don't point. We've watched this video, you know.
Right.
We watched the evidence. There's nothing that shows they had any recognition that there was a spill there. They're having a conversation. A third person comes up, they hug. There's nothing to show that they're trying to avoid or notice a spill. They're not like saying, I'm not going to clean it up. Maybe you go get the guy with the broom and he'll come over here for the 5th time. You know, there's nothing going on that tells us that they noticed that spill. So I don't know how you can make that inference. Can you help us with that?
Your Honor, I would point to, number one, the fact that they're standing directly over for 2 minutes is in line with the Walmart's training that the employees were deposed, and they talked about how they're trained to stand near a spill until the hazard is cleaned.
They're not standing near a spill till action's taken. They go on their merry way.
Well, right.
They're not standing there for the spill. They're just talking. They're not, and then people are walking back and forth over the alleged spill site continuously. It's the busiest central corridor that people of all different people. Some people with carts, some people with big dress. I mean, it's just a lot of people walking over the alleged spill.
Yeah, and I would point, Your Honor, to the fact that, and I understand that proving actual knowledge, I think, is really the harder part of this. I think that's safe to say. I think we have better evidence on the constructive knowledge. But I'd also point the court to the fact that during the whole 2 hours of the video, there's no other point where we see employees huddled together like this for more than a few seconds. Literally the only time in that 2-hour video that you see them together, like just standing in this aisle for the 2 minutes, is when the spill is there. And then they disperse when there's somebody coming up the aisle with the cleaning tool, which again, it doesn't happen any other time in that 2 hours of video other than during that 12 minutes. And so I understand that this is not, we can't conclusively prove it here.
I don't see how that's actual knowledge. Did you depose those two people, and did they say they were standing over there, or either way, you know, that may be.
No, those two individuals were not deposed in the case, and so there's no evidence either way as to what they would testify to as to whether they saw it or not.
Okay, how does Trahan's witness statement corroborate? Because Trahan's alleged witness statement, is only that another associate told Trahan that the customer slipped on the liquid.
Right. His witness statement is another associate let me know about it, and it's implied there that because he was an early responder, the witness statement says that he was the first responder, even though he was actually a second responder. But when you see that, it raises the question, now, when was he told about it? He's saying another associate let me know about it. He has a radio, which the other employees who are all there don't necessarily have radios, but he did.
But I don't understand how that corroborates the.
Well, he was the one that was coming up to clean. He was the one that was coming up the aisle. And so if he was told about it, he's coming up to clean it. That makes sense in line with the employee standing there. And I understand this is not open shut by any means on that point. But our point on the actual notice is that when you look at this evidence and the totality of the circumstances, that there is at least enough evidence here to get past the summary judgment threshold.
What about the fact that customers and employees repeatedly walked through the liquid without even seeming to look where the liquid would be, without even seeming to look down or having any issue Isn't that fatal to constructive knowledge?
Well, with respect to constructive knowledge, that fact, I would point this court to the case of the Garcia versus Wal-Mart case from 2018 that this court decided, where there were similar facts, and in that case there were, I think, 13 people that had walked through the area, and Wal-Mart made the same argument that, well, if all these people are walking through the area, how do we know that the spill was there? And the court rejected that argument.
Even if it's there, it's not, they're just walking right on through. It's not where the alleged spill is.
Well, I don't think that that necessarily goes to, that might be evidence that weighs against the conspicuity part of it, perhaps, but I don't think that goes necessarily to the timing that the spill was there or the proximity of the employees.
On either constructive or actual knowledge?
I think the best evidence, well, first of all, the video surveillance establishes that we have the time of the spill and the time of the fall, so we have temporal evidence here, and that automatically distinguishes this case from many of the other cases that Wal-Mart cites to, where they had no video surveillance or no temporal evidence establishing the amount of time that it was there. So that's the first step, is to show that, okay, it was there for 12 minutes, which we can see because just like in the Garcia v. Wal-Mart case, where they had an automated floor scrubber that went over the area, paused for 2 seconds, and then kept going, the court said that was sufficient evidence to show the creation of the spill.
How is the video helping you with the notice to Walmart?
Because the video shows that, number one, we can see the creation of the spill, the time that it was there, and then we can see that there are 6 employees in the direct vicinity of the spill. There were 2 employees standing inches away from the spill for 2 straight minutes. There's another that joined them for 30 seconds, and then later another one for 30 seconds.
So what's the inference to be drawn by what we see in the video of them standing there? What's the powerful inference you want us to draw, or the district court should have drawn?
The only inference there is that there are several employees in proximity giving Walmart a reasonable opportunity to discover the spill. That's the central inquiry here. It's a reasonable inquiry. Did Walmart have, yes?
It seems to me the logical reaction is they couldn't see it. It was clear. Nobody tried to clean it up. Nobody tried to put those little cones you put when it says wet floor.
Right.
Seems to me that it weakens you. I mean, it destroys your position. If 6 employees were right there and didn't see it.
If they didn't see it, there still may be constructive knowledge that they should have seen it, that they had a reasonable opportunity to discover it. And there is evidence here as to it being a conspicuous spill, not because of the color, it was clear liquid, but because of the size. And if you look at the Boettcher brothers v. Aldridge case from the Texas Supreme Court in 2014, in that case they discussed that the size of the spill can make it conspicuous regardless of the color. There was a Walmart employee who spent almost 5 straight minutes cleaning this up with paper towels. This was not a small wipe up a few drops of water. This was.
Well, she was just kind of stepping on it. It was not a 5 minutes of cleaning.
Not intense scrubbing, right?
It was not really that. I don't think the duration of her stepping around is evidence. Go ahead, I'm sorry.
Well, I would disagree in the sense that I think that it does show that there was a large amount of paper towels. This was not a small spill. That's not the amount of paper towels and time you'd spend cleaning up a small spill. And they brought in a floor scrubber afterwards, which Walmart employees testified, the purpose of which is to clean liquid spills. And so this shows that this is not a small spill. And the Boettcher brothers v. Aldridge case had the same type of evidence, where the court looked at it and said paper towels were not enough. And so that's evidence that this could be a large spill, and it's conspicuous. And so the court's...
The problem with that, though, is how is it conspicuous if everybody is just walking right? There is not one single person that's saying, scoot over to your child, get away from the water. There's not one of the many, many people take any evasive action or point to it or do anything that if there was a conspicuous spill, you would expect that not everybody would just trudge right on through.
I would disagree. I think there are 2 points where it's arguable that there are a couple of people that do seem to walk around it, and I think those sites are in our brief, and I can give them to you if you want, but there are a couple of points where it looks like...
They're going the other way down that side aisle. I thought at first, but it looks to me like they're going down the side aisle.
But regardless, I think that may go to conspicuity, but at the same time, we still have the evidence here that establishes the time of the spill, that establishes that it was there for 12 minutes and that there were 6 employees in the immediate vicinity. And so under the law, the Texas law, that means that Walmart had a reasonable opportunity to discover it. The proximity shortens the amount of time, even if you disagree on the conspicuity part.
I was looking at this case and trying to figure out why it was in federal court and if it was over the threshold, but it seems that you pled $1 million in damages. What are the injuries in the case?
I believe she injured her knee, she injured her ankle, she injured her back. She had some injections in there. I believe there was a surgery recommendation as well, and I think it was a surgery recommendation that ramped up the damages. I wasn't trial counsel, so I'm not as intimately familiar with the damages side of it, but I believe that all of that got on over to 75.
You're not complaining that we're here
No.
in federal court. Now, I mean, I didn't see that, but I was just thinking from the fact that she's walking right off and kind of moving her leg up and down, but able to just go about her business, it didn't. I
believe she had about 6 months of physical therapy, and there were some injections and surgery recommendation, and that's what pushed it over in terms of the limits. But I think the key point here, Your Honors, is that what distinguishes this case from the Walmart-cited cases is that we have temporal evidence here. Almost all of those cases lack that evidence. They don't have video surveillance. They're relying on negative inferences as to the timing of the spill. So once you have the timing of the spill, then it's just a matter of, well, is 12 minutes long enough for Walmart to be able to discover it? And that's all the inquiry is.
But you showed the video to Judge Hoyt, right?
Yeah, well, I believe he viewed it. There was not an oral hearing.
I mean, but he saw the video.
Yes.
Right? I mean, the video hadn't been hidden from anybody.
Right. He saw the video.
So what'd he miss? I mean, he saw what we saw. We've all looked at it.
I think that if you look at his order, he even says, well, we don't know if the spill even occurred. And respectfully, I thought that was blatantly incorrect because Walmart employees even testified that they had contemporaneous statements that there was liquid on the ground. They submitted an insurance claim based on there being water on the ground. So the idea that he said that there wasn't even evidence there being liquid on the ground put his order into some question. And we discussed in our motion as well how he conflated the actual notice and the constructive notice standards. And so I think maybe that's how he came to his decision, but I don't want to speculate too much on it.
I mean, as a general proposition, of course, we say you construe things in the light most favorable to the non-moving. But when you had this video at play, it sort of when everybody can see what everybody can see.
I think that it was an error, Your Honor. I think that's why we're here asking for the court to reverse, because when you look at the video, you can see that there's no other equally reasonable inference that can be made as to the creation of the spill. This is the only
That's an
time.
argument to be made. You might be better off if you didn't have the video, really. That's just me. I'm not deciding it, but I'm saying, there's an argument to be made. If there is no video and you say construe it in the light most favorable to the plaintiff, you may say, well, maybe it's a package. But once you have this surveillance, it's 12 minutes. There's no dispute about the length of it. And it's just kind of there. So what case, if any, does your video in this case maybe come closest to?
I would point the court to, there are 3 cases overall I'd point the court to. One, like I said, is the Brookshire Brothers v. Aldridge case out of the Texas Supreme Court, because there was video that it was a spill for 7 minutes and they couldn't see the spill in the video. I would also point the court to the Garcia v. Wal-Mart case that this court decided in 2018, where the video surveillance didn't show the liquid, but there was still enough there to survive summary, or to reverse summary judgment that was the creation of the spill. And then we also cited in our brief the Sheffy v. Wal-Mart case, in which has very similar facts in terms of the timing, the number of employees in the area, and the type of conspicuity evidence. But the video surveillance, I think, is important here because that distinguishes this case from a lot of the other cases that are cited by Wal-Mart. And we're not saying that we have conclusive evidence proving this. We're saying we have enough that Wal-Mart had a reasonable opportunity, enough to get this past the summary judgment threshold so a jury can look at this video and make its interpretation of the video.
All right. I think we have your argument. Thank you, sir.
Thank you.
All right. Wal-Mart.
May it please the court, Eric Boettcher for the Wal-Mart appellees. 2 principles of Texas law demonstrate why this court should affirm the district court's grant of summary judgment to Wal-Mart on Agbonzee's premises liability claim. First, Evidence that merely raises suspicion of an essential fact or merely shows the possibility of the essential fact is legally insufficient to establish a genuine issue for trial. And here, the speculative and circumstantial evidence Agbonzee cites at best merely raises suspicion that Wal-Mart had actual or constructive knowledge that clear liquid was on the floor of an aisle before Agbonzee slipped on it. And second, courts applying Texas law have regularly held that inconspicuous hazards that have existed for longer than 10 minutes are legally insufficient to show a premises owner's constructive knowledge of the hazard. So even assuming that there's evidence that the clear liquid Agbonzee slipped on came from a person spilling a drink around 11 and a half minutes before Agbonzee slipped, that is legally insufficient to show Wal-Mart had constructive knowledge of the liquid. So I'm going...
People are standing right on top of it.
Yes, Your Honor. I think that the proximity evidence in this case is materially weakened by the fact of how inconspicuous the liquid was and that it was only on the floor for around 12 minutes. So I'll begin with the inconspicuousness. As the court was discussing earlier, around 25 people walked directly through the area of the spill between the time it allegedly happened and between the time of Agbonzee's spill. And no one avoided the area or looked down or did anything out of the ordinary. They just walked right through. And I would argue that means it's by definition inconspicuous. And opposing counsel cited the Garcia v. Wal-Mart case where 13 people had walked through the area and this court had concluded that that was not enough to show that the liquid was not there. We're not trying to use it for evidence that it wasn't there. We're just saying it was inconspicuous. And also, 13 is, approximately half as many as 25 here too. I think that that's just weaker evidence in terms of numbers.
So you don't take a position or do you admit that the person with the cup and the bottom of the cart thing actually did spill a liquid?
Our position is that the video is legally insufficient to show that. The video quality is very low. It's grainy. There's no liquid on the floor at any point.
Does it matter for your argument today whether the person spilled anything from their cup? Does that matter in this case?
That would be an alternative ground, but we think we win on constructive knowledge too, even assuming that the liquid was there, that spilled at that moment. So turning back to the conspicuousness factor and how that relates to proximity, opposing counsel was discussing the size of the puddle and arguing that that makes it so there was evidence of conspicuousness, but I don't see how the size is relevant where that's just a proxy for conspicuousness, and we already have evidence of 25 people walking right through that area, if that's where the spill was. So I think regardless of size, it was inconspicuous, and you can't really rely on size to show it. And in regard to the Boettcher v. Aldridge case, the substance there was not a clear liquid, it was chicken grease, and the court there didn't say anything about that grease being transparent or difficult to see. There was nothing about people avoiding the area or not walking through the area of the grease. And in addition, there was separate testimony in the Boettcher v. Aldridge case where an assistant store manager said, in this store, we should reasonably discover and remedy a hazard within 5 minutes of it being on the ground. So I think with those two things, the Texas Supreme Court concluded that 7 minutes could create a fact issue where there's chicken grease and you have that admission from the store. I think we're in a different position here. And taking a step back too, there's not evidence that the spill was even large here in the first place. Agbonzee testified that she can't remember how big the spill was. They're really reading a lot into one employee taking around 5 minutes to clean up a spill with paper towel, but we don't know what that employee's habits were or how diligently she was cleaning it. They did not depose that employee. We're just kind of left with trying to really infer a lot from just the time of the spill. And in any event, too, under plaintiff's theory, if someone spills a drink while drinking from it, that would be a small amount of water, and it's not as if they're letting someone dump a gallon jug of water right in the floor. So we don't really see there being any evidence at all of it being a big spill in the first place.
The district court did not grant the motion for reconsideration.
That's correct.
And there's an expert report included with the motion for reconsideration would that create a fact issue? And if so, did the district court err in any way?
So, first of all, that expert report shouldn't even be considered it was correctly not considered by the district court, and it should not be considered by this court either. There was no reason for them not to put that in their summary judgment evidence. It was available, but the explanation was that Agbonzee did not want to burden the court with extra evidence. And when that's the situation, the case law of this circuit holds that it's not appropriate to attach that evidence and motion for reconsideration. And secondly, the substance of that expert's report, he basically just says the same things that Agbonzee's saying in her brief. It's very cursory, saying someone spilled a drink at around 4:42 p.m. There's people standing nearby. The Wal-Mart employees should have seen it. That was a reasonable opportunity for them to discover it. So I think when an expert report's conclusory, the law of this circuit is that it doesn't amount to evidence and can't create an issue to survive summary judgment. So I don't think the expert report's much of an issue. And I'd just like to turn back to how, after we finish talking about conspicuousness, how proximity interacts with that. And proximity, I think, when something's very inconspicuous, it doesn't really play much, if any, of a role. The touchstone for whether a store has constructive knowledge of a hazard is whether it has a reasonable opportunity to discover a hazard. And here, assuming the liquid was on the floor for 12 minutes before Agbonzee slipped on it, it was so highly inconspicuous that 25 people would have walked through it before she slipped. And when it's that hard to detect, the employee's proximity to the location does not make it so the time for Wal-Mart to have a reasonable opportunity to discover and remedy it is reduced in any material way, if at all. And so I think under Agbonzee's theory, where we have a highly inconspicuous liquid that's on the ground for less than 12 minutes, that's determinative of the constructive knowledge issue. And I think that's in full accordance with this court's recent opinion in Robbins v. Sam's East, which is a case that's discussed in Wal-Mart's brief. And the Robbins court noted that under Texas law, inconspicuous hazards that existed for longer than 10 minutes have been held to be legally insufficient to show constructive knowledge. And then the court accepted plaintiff's contention in that case that an inconspicuous piece of fruit had been on the floor for 10 minutes, and it was in close proximity to two employees who were continuously positioned at a kiosk, and the court still ruled that that was legally insufficient to create a fact issue on constructive knowledge. And I think the proximity evidence in Robbins is even stronger than we have here, as those employees were continuously stationed in close proximity for the entire 10-minute period. Here we have no Wal-Mart employees that were in the area of the spill for a continuous and significant period of time. Wal-Mart employees were coming and going from the area. The longest any particular employee was there was for 2 minutes. So I think this all shows that even assuming that the liquid was on the ground at around 4:42 p.m. and 11 and a half minutes passed before Agbonzee slipped on it, that is not sufficient to create a fact issue under Texas law, and that Agbonzee's failed to carry her burden on constructive knowledge. Unless the court has any more questions about constructive knowledge, I'd like to briefly address actual knowledge. So, as I explained, we're not conceding that the liquid was on the ground at 4:42 p.m. when the person with the two children allegedly spilled a drink, but even assuming it is, Agbonzee's theory for actual knowledge is just too speculative and just relies on multiple pieces of suspicion stacked on top of each other. So first of all, the mere fact that there were Wal-Mart employees that were standing in the area of the spill does not show that they were responding to a report of a spill or were trying to block it or anything in accordance with this Wal-Mart policy. The video shows that they were just socializing and were not looking at the ground. And I think any notion that they're trying to block the spill is defeated by the fact that when they show up in the area at around 4:46 p.m. in the video, they let a customer walk directly through that area without stopping him. And then around a minute later, they let another customer walk directly through the area without stopping that customer. So I think that any notion that they're trying to block the spill is untenable in light of those facts. And in regard to Jock Trahan, the employee with the horizontal flat broom, that also doesn't show that there's any evidence that he was there to clean the spill. First of all, there's no evidence that the horizontal flat broom he was using was an appropriate piece of equipment to clean a puddle of water. In this case, it was in fact ultimately cleaned by paper towel and a floor scrubber machine. And more importantly, it just doesn't make any sense that he would arrive in the area with the mission to clean it, but then suddenly change his mind, leave the video for a little bit, and then come back and sweep the opposite side of the aisle. So I think that the theory for actual knowledge is affirmatively contradicted. And unless the court has any questions about actual knowledge, I'd like to just briefly conclude by discussing the Rule 36 admissions that Agbonzee made, which we submit as a separate reason for affirming the trial court's grant of summary judgment. Under Rule 36B, in this court's holding in In re Carne, Rule 36 admissions are conclusive as to the matters admitted and overcome contradictory evidence at the summary judgment stage. So we're saying that there isn't sufficient evidence anyways of actual or constructive knowledge, but even if there were, they'd be contradicted or they'd be overcome by Agbonzee's admissions that she did not know how the liquid got on the floor, how long.
That's like a weak point. The fact that whether she noticed or not, that's not her job. I don't understand how her knowledge is. You say it's, admissions, and so it's dispositive. Whether she knew or not is not the issue in the case. Yeah. So it can't be it's not a normal kind of admission that you would say they admitted the key fact that's on them. It's not on her. So I don't get this point at all.
Okay.
So maybe if you want to help us get it, or if you want to move on, either way.
Okay. Yeah, our point was that in submitting the request for admission, some of the requests were keyed to Agbonzee's personal knowledge, asking if she had personal knowledge of the liquid on the floor. Then others asked the exact same thing, but just whether she knows that it was there. And I think that goes beyond personal knowledge and includes just what she knows on evidence in the case with the assistance of counsel. And I submit that is an admission that the evidence was insufficient. But beyond that, that's the explanation of our position on that point. So unless the court has any questions about any of these topics, I'm prepared to yield my time.
All right, sir, I think we have your argument. Appreciate it. All right, rebuttal, Mr. Hawley.
Thank you, Your Honors. Let me start by addressing a couple points we kind of discussed earlier regarding the conspicuousness of the spill. I would point to the court that just because customers didn't notice it doesn't necessarily make it inconspicuous. The customers don't have a duty to be inspecting for spills the way the Walmart employees do. They're looking at the shelvings, which is up high. They draws their eyes upward. It's not their job. Mrs. Agbonzee testified that when she fell in it, she noticed there were a lot of scuff marks through it and tire marks through it. And it was at that time she also talked about how she thought it was a large spill. Now, she did back off of that testimony a bit on further cross-examination when asked about the exact size of the spill, but she testified that she thought it was a large spill. I would also point out that the fact that the employees didn't adhere perfectly to their training or to Walmart's policies did not necessarily cut against the actual knowledge point. I think that's why we have a negligence case here. Opposing counsel brought up the Robbins v. Sam's case. That was a case where there were employees 5 to 10 feet away from fruit that was the size of the head of a ballpoint pen. Okay, that's not the same as a large spill, whether it's clear or not. And there was no video surveillance there, and I believe they believe that it was up to 10 minutes that it could have been there, but it was a negative inference. That was when they thought it was there. There was nothing establishing the amount of time. And that's a key point for all of these cases, is the lack of temporal evidence. Regarding the admissions, very briefly, I think that Judge Elrod, you were correct. I think that that it's a stretch to say that somehow Mrs. Agbonzee viewing the video would change her personal knowledge. Was asked about what her knowledge was at the time, and just because she saw the video, it may lead her to reasonably believe that something is more likely than not. It doesn't change her personal knowledge. So the admissions are really irrelevant. And I think that you have a case here where you have 6 employees who are, in some cases, inches away from a spill for 2 straight minutes. Wal-Mart cites to no other cases where there is proximity evidence at that level, where there's temporal evidence at this level, and the court affirmed summary judgment. There is no other case like this where summary judgment was affirmed. This case is more like the Sheffy case, more like the Boettcher brothers case, more like the Garcia v. Wal-Mart case, where summary judgment was upheld or a jury verdict was affirmed. If this is a case where constructive notice if this is not constructive notice, then it's going to be very difficult for plaintiffs in the state of Texas to ever prove constructive notice. We have video surveillance, you've got employees standing right over the spill, we've got testimony that it was a large spill, we've got evidence and cleanup that this was a large spill. What else do you need in terms of reasonableness for Wal-Mart to be able to discover this? They had plenty of employees in the area. It's a busy Saturday afternoon. They have training that teaches them to be inspecting for these types of spills. This is certainly a case where there's sufficient evidence for summary judgment purposes to get us over this threshold on constructive notice. And I understand that proving actual notice is much more difficult, but if you are with us on a constructive notice, you don't need to get to the actual notice part. And then finally, I would just submit that the court has discretion to consider the expert report as part of the motion for reconsideration, and I think that further bolsters the evidence. I don't think it's necessary. I think that the evidence on its own, the summary judgment evidence that was presented, is sufficient here, but the expert report does further corroborate and bolster the evidence here. So unless you have any other questions, I'll concede the rest of my time.
All right. Thank you, sir. I believe we have the arguments on behalf of your client. Excuse me. Thank you to both sets of counsel for the briefs and arguments submitted in the case. This concludes the oral arguments for this morning. These cases, along with those that have been submitted, non-oral argument, will be submitted for decision. The panel will stand in recess until 9 a.m. tomorrow morning. Thank you. All right.